A power of attorney is supposed to protect your loved one. It's meant to help when an aging parent or relative can no longer manage their finances, medical decisions, or legal affairs on their own. But in California, I've seen something very different happen far too often. Instead of protection, that power becomes a weapon. I'm Michael Hackard, and for more than 50 years, practicing estate and elder law across California, I've watched the same pattern unfold again and again. A family member, a caregiver, or sometimes a new romantic partner gains power of attorney over a vulnerable elder, and once they have it, they abuse it, sometimes slowly, sometimes shockingly fast. So let's talk about what power of attorney abuse really looks like, why it so often leads to inheritance theft, and what California families can do to fight back. First, it's important to understand what power of attorney abuse actually is. A power of attorney gives one person, called the agent, legal authority to act on behalf of another person, the principal. That authority comes with a fiduciary duty, meaning the agent must always act in the principal's best interest. Abuse happens when that duty is violated, when the agent uses their authority to benefit themselves instead of protecting the person they're supposed to help. In California, we see power of attorney abuse show up in very specific ways. Unauthorized financial transactions are common. Bank accounts drained, credit cards used, investments liquidated without explanation. Property transfers are another red flag. Homes deeded into the agent's name or sold below market value. Then there's isolation. Family members suddenly can't reach their loved one. Visits are blocked. Information is controlled by one person. Healthcare decisions may be manipulated. Medical choices are made for convenience or control rather than the elder's well-being. And finally, estate documents quietly change. Wills, trusts, and beneficiary designations are modified during periods of confusion, illness, or fear. These actions don't just cause financial harm, they often lead directly to inheritance theft. In my experience, elder financial abuse and inheritance theft are not separate problems. They are connected. The pattern is remarkably consistent. It usually starts with the approach. Someone positions themselves as helpful, devoted, indispensable. They gain trust. Then comes isolation. The elder becomes harder to reach. Phone calls go unanswered. Family members are told not to worry. Next come the documents. New powers of attorney appear. Wills and trusts are amended. Beneficiaries are changed, often when the elder is medicated, cognitively impaired, or emotionally dependent. Finally comes the theft. Accounts are emptied, property is transferred, and when the elder passes away, the family discovers the estate has been hollowed out or they've been completely disinherited. By the time most families realize what's happened, the damage is already extensive. That's why recognizing warning signs early matters. Financial red flags include unexplained withdrawals, missing statements, unpaid bills despite sufficient income, or new names added to accounts. Behavioral changes matter too. Confusion about finances, anxiety around money, a new person who suddenly controls everything, family members being excluded from conversations or visits. Legal warning signs include new power of attorney documents you were never told about, recent changes to a will or trust, or a loved one who doesn't even remember signing paperwork. If you're seeing these signs, time matters. California law does provide strong tools to fight power of attorney abuse, but those tools come with deadlines. The first step is documentation. Bank records, property records, medical files, communications, a clear timeline of suspicious events. Evidence is critical. Families may be able to revoke a power of attorney if their loved one still has capacity. If not, California probate courts can step in. Courts can force accountings, remove abusive agents, recover stolen assets, and impose damages for breach of fiduciary duty. In serious cases, California's Elder Abuse and Dependent Adult Civil Protection Act allows victims to recover stolen assets, pain and suffering damages, attorney's fees, and even punitive damages. There's also a powerful provision in California law that allows abusers to be treated as if they predeceased the victim. In plain terms, that means they lose any inheritance they tried to steal. But deadlines apply. Trust contests and will challenges often have a 120-day window. Elder abuse claims typically must be brought within 4 years of discovery. Waiting too long can close the door on recovery. Many families worry about legal costs. The reality is that experienced elder abuse attorneys often work on contingency for qualified cases. That means no upfront fees and no legal bills unless money is recovered. Let me share a real example. A Sacramento family came to us after their father passed away. During chemotherapy and cognitive decline, his stepdaughter obtained power of attorney. Over 18 months, she transferred more than $800,000, changed beneficiaries, and amended his trust to cut out his biological children. The pattern was clear: isolation, document manipulation, financial theft. We pursued elder abuse claims and trust litigation together. The case resolved with a substantial recovery, and the family's inheritance was restored. That's why understanding the full pattern matters. When attorneys only look at one piece, families lose. Prevention is always better than litigation. Have estate planning conversations early. Stay connected. Monitor finances with permission. Never give financial power of attorney to a caregiver. And work with experienced professionals who understand these risks. If you suspect power of attorney abuse, don't wait. A power of attorney should protect your loved one, not become a weapon used against your family. If you need help, reach out. Getting the right guidance early can make all the difference. Hackard Law represents heirs and beneficiaries in estate and trust litigation in the San Francisco Bay Area and throughout California. You can call us today at 916-313-3030. We look forward to hearing from you.